Ladies and gentlemen, welcome to Faculty of Law, Chulalongkorn University. Today, we are very happy and honored to be hosting an academic seminar on international humanitarian law entitled The Continuous Relevance of IHL in Contemporary Armed Conflicts, Time to Elevate it to a National Priority. Today, we are hosting this event in cooperation with the International Committee of the Red Cross, ICRC, Bangkok. So without further ado, may I invite Professor Dr. Margherita D'Ascanio, Dean of the Faculty of Law, Chulalongkorn University, to give a welcome remarks.
Swadika, and good afternoon, distinguished Professor Raul Pangalangan, former judge of the International Criminal Court, ICC, Mr.Andre Smit, Mrs. Margherita D'Ascanio from the ICRC Bangkok, Dr. Panu from the Political Science faculty, esteemed colleagues, and distinguished guests and students. On behalf of the Faculty of Law, Chulalongkorn University, I extend a warm welcome to each of you to this panel discussion on the continuous relevance on IHL in contemporary armed conflict, time to elevate it to a priority. This panel discussion is co-organized with the International Committee of the Red Cross, the ICRC, thank you very much, and it's organized in a timely manner to address a matter of paramount importance, the unwavering significance of respecting international humanitarian law obligations by all parties in armed conflicts. From the heart-wrenching scenes in Yemen, Syria, Ukraine, to the enduring complexity of the Israel-Palestine situation, the human cost of these conflicts is profound. However, the international humanitarian law is a beacon of hope. Of the Geneva Conventions, the 1949 and their additional protocols and other relevant IHL treaties stand as a testament to humanity's collective commitment to safeguarding the rights and dignity of individuals, regardless of its status, whether combatant or non-combatant. Although majority of states in the world are the parties of these relevant IHL treaties, the true success of IHL depends upon the observation of IHL in its implementation. Therefore, in this panel discussion, the key questions are how we can ensure that all parties in armed conflicts, states, non-state actors, and armed groups genuinely respect their IHL obligations. What mechanisms can be put in place to hold violators accountable and the challenges of the IHL applicability to the new form of warfare such as cyber and other digital operations. The Faculty of Law at Chulalongkorn University as an academic institution commits to promote and disseminate IHL core values. This panel discussions is also the kick-off event for the national rounds of International Humanitarian Law Moot Court competition, another venue to raise awareness among students, the younger generation, of the pivotal roles of IHL in time of armed conflicts. I wish and believe the distinguished speakers have fruitful discussions and the audience collects important key takeaways to reaffirm our collective commitment to upholding the principles of humanity. Let today gather be a testament to our unwavering dedication to this cause. Thank you.
Thank you very much, Dean Parina, for your welcoming remarks. But before we move to a very much anticipated, much awaited academic discussion, we have a keynote speech given by our very own Professor Emeritus Vitit Mantaporn, a Professor Emeritus of Faculty of Law, Chulalongkorn University, and also the Special Rapporteurs on various UN mandates. Unfortunately, he cannot be able to join us at this event due to his other commitment abroad, but he kindly gave us a pre-recorded speech on the issue. So, ladies and gentlemen, please welcome Professor Witit virtually.
Hello everyone, I'm Vitit Mantaborn, teaching at the Law Faculty, Chulalongkorn University in Bangkok, and welcome to this session. I've been asked to talk a little bit about strengthening protections in times of war, and this is the realm of international humanitarian law, particularly to protect people from victimization. Innocent civilians, fallen soldiers, those who are not in the combat situation, but outside the combat situation. This is the realm of international humanitarian law. If we look at IHL, or international humanitarian law, actually the roots in this region beyond are very old. You can trace back the roots to Indian traditions, Chinese traditions, Thai traditions. Advocacy of protection of prisoners of war was there thousands of years ago, actually, at least over 1,000 years ago. Innocent civilians to be protected, poison darts, which should not be used, advocated 1,000 years ago in the scriptures of this region. So what we're building upon is beliefs and commitments, particularly through more formal processes of treaties as well as good practices. And we do have treaties and conventions on this front about which we can learn and talk and try to practice. So let me look at 4, 5, 6 elements of IHL, humanitarian law, in today's world, particularly the relevancy when we're faced with today about 100 wars, many civil wars, but also some interstate, international wars today, sadly. What are some of the elements, priority elements at play? Number one, we need to improve compliance, monitoring, as well as implementation, enforcement of international humanitarian law. What does that mean? Well, there are many, many treaties on this, many conventions, and the main ones that might be familiar to you are the 4 Geneva Conventions of 1949. Geneva Convention 1, 2, 3, 4. 1 concerns protection of wounded soldiers on land. Number 2 concerns protection of wounded soldiers at sea. Number 3, protection of prisoners of war. And number 4, protection of civilians, particularly in times of occupation by the other side. The basic principles are probably familiar to you already, and they include, number 1, the need to distinguish between civilians and military. No attacks on civilians and their objects, please. That is the principle of distinction. Number 2, the military can only act on the basis of military necessity, not for other reasons. Number 3, if and when they act, they must weigh the pros and cons of their acts, and that is the principle of proportionality. Attacks should be avoided if they might cause excessive damage when interfacing with the military advantaged. Number 4, the principle of precaution, which means the need to warn civilians and others when attacks might take place, which could lead to particularly damage to civilian population and related civilian objects. And number 5, overarching principle of humanity, advocating basic respect for this law in times of both international armed conflict as well as non-international armed conflict, international war and civil war, integrated into a certain understanding under a certain umbrella of the need to protect the innocent. That advocacy calls into play also the need to integrate various prohibited acts, crimes into our national setting in terms of laws, policies, and practices. And the four crimes, international crimes today, are war crimes, crimes against humanity, genocide, and crime of aggression. At least 2 or 3 of those should be in our laws, policies, and practices. War crimes are misdeeds in times of war under the Geneva Conventions that I've just mentioned, but also more, such as use of child soldiers under 15 is an international war crime under customary rules as well as other treaties. Prohibition of various weapons might not be under Geneva Conventions 1, 2, 3, 4, but that prohibition is found in other international treaties and practices. So please integrate war crimes into the national setting as a prohibited act or prohibited acts. Number 2, crimes against humanity, which covers particularly acts in war and peace, and that entails particularly attacks, widespread or systematic attacks on the civilian population. That should also be prohibited and integrated into our national setting. Number 3, genocide. Genocide is really attacks on a particular group with intent to destroy. It might mean killing, but it's more than killing. And this is a very important consideration in terms of understanding of the concept. Some countries understand this as killing, only killing. It is not only killing. It's different acts of violence against a particular group with the intent to harm. And that is also covered by a separate treaty known as the Convention on Genocide of 1948. And then the 4th element to be prohibited is the crime of aggression, which is really war-related planning, incitement in breach of the UN Charter, manifest violation of the UN Charter. So those are elements which should be integrated into the national setting. And as part of law, they should be well monitored in terms of compliance and implementation with due regard to accountability ensuing from violations. 2, the issue of refugee protection. Very important because even near here we have an armed conflict with huge influxes of people coming into play into our various countries nearby. The actual constituents of refugee protection that are found in general international law as an addition to the more specific approach of international humanitarian law. What do I mean? IHL traditionally didn't cover the rights of refugees so much in times of war, but those rights are covered by a separate treaty, particularly the 1951 Refugee Convention and its 1967 protocol, together with international law. That linkage between IHL and international law as a whole is important, particularly to advocate 1 or 2 key elements of the rights of refugees. The right not to be pushed back to dangers, that is known as non-refoulement. That is found in general international law today, adding to the precepts of IHL that I voiced earlier, together with access to temporary refuge and the basics of life. So please read IHL, International Humanitarian Law, together with international law as a whole on this front. Thirdly, the issue of missing and enforced disappearances. Today, we have a relatively new treaty internationally, the Convention Against Enforced Disappearances. And that adds on protection to the coverage of missing persons, which is also found in international humanitarian law. Enforced disappearances under the new treaty would be described as deprivation of liberty done by state actors or omission as regards non-state actors, whereby the state should act against these non-state actors, and then a certain sort of collusion to hide the whereabouts of the person subject to enforced disappearances. This is now a crime internationally and should be covered locally in our laws too. Slightly broader than that is the issue of missing generally in times of war and violence. And this coverage that we should offer also to the missing is guided also by the Red Cross guidelines on missing persons. And this includes trying to make the situation transparent, tracing, monitoring, helping families, helping to trace the whereabouts, as well as, sadly, if people have died, to enable remains to be returned to the families with cooperation between the various stakeholders. So this issue is now covered more by a new treaty, but also we shouldn't forget the traditional coverage of IHL as regards missing persons. The next issue is neutrality. Neutrality. And previously maybe one was not talking too much about it, but today, because there are very key international wars between states, together with many other non-international wars, the issue of neutrality also has to be borne in mind. And we can trace the rules on this backwards to decades and decades ago, particularly the Hague Conventions, the Hague Rules of 1907, to which some countries in this region, including Thailand, are parties. Hague Rules on neutrality cover both situations on land as well as situations at sea, and basic components can be analyzed and identified, including, number one, the advocacy that the neutral state should not allow through the state munitions of war to the warring parties. This country, C, neutral, should not allow munitions of war to go through C to go through to A and B, the states which are at war. Another principle which is important is that this country, C, should not show any hostile acts towards the warring parties. Passive, peaceful is the name of the game. Thirdly, if the military of the so-called belligerents A and B come into this territory C, they should be kept away from the border, particularly residing in an area far from the border, so as to ensure that we are not involved directly or indirectly by implication in the possibility of hostility and warfare. And then finally, as another rule, as an example, is that if it's a naval situation of ships, warring ships coming into our ports, we should try to get them out within 24 hours. And that's one of the precepts of the Hague Rules of 1907. These elements of neutrality are important today, as I said, because we have at least one or two major international wars that have sadly crept up on us very recently. And we should try to bridge well to end those wars. Finally, the issue of technology and then accountability. The world is very interested in digitalization, cyber wars, and even more recently, artificial intelligence, particularly lethal autonomous weapons that might decide to kill, automate itself to kill. Traditionally, international humanitarian law didn't cover this too much, and you had to look to other elements, particularly through the disarmament arm of international law, to cover these weapons which might cause suffering, unnecessary suffering, superfluous injury. And we have one major treaty that is very much related to this spectrum, adding to the international humanitarian law traditionally. And this major treaty is the 1980 Convention on Conventional Weapons. Countries need to ratify this treaty, especially because this treaty is now on the verge of being expanded by a protocol, by an additional treaty to cover lethal autonomous weapons, particularly the killer robots, particularly to prohibit them. But there's also another track through the United Nations whereby we might have a totally separate treaty, not just a protocol to the Convention on Conventional Weapons, but a totally separate treaty to deal with killer robots and autonomous weapons. The message here is that we must also be involved in the reins of control and prohibition to ensure that humans are still involved, especially when robots are appearing today with their generative possibilities of deciding for themselves and producing new data, producing new decision-making tools for themselves, as well as to actually act to kill, even without human command. But we want to be in command, please, and that is the undercurrent behind the negotiations today. Last but not least, accountability. Traditionally, the laws of war, as well as the international humanitarian law, particularly through the 4 Geneva Conventions of 1949, as expanded by 3 protocols after that, on elevating wars of self-determination to international war, on increasing coverage of non-international armed conflicts, and then the last, more recent Protocol 3 was and is to introduce a new symbol of protection, which is the red crystal, in addition to the traditional Red Cross and Red Crescent symbols. Now, in terms of accountability, in this expanded framework of international treaties that we have today, we could say that traditionally in that expanded framework, the expectation was to look to the locality to take action. But this has been enhanced internationally by the presence of the International Criminal Court. However, that enhancement is limited in Asia because many countries, most countries, are not parties to the International Criminal Court. So we have to look to the state, the internal setting, the locality, to have measurements, mechanisms, tools and processes of accountability, particularly through our courts, through our laws. One element, as voiced earlier by me, was to integrate various crimes into our national laws: war crimes, crimes against humanity, genocide, and crime of aggression. Another element in terms of possibility is to expand, or at least to strengthen our jurisdiction on the basis of broadened jurisdiction to cover misdeeds. Usually jurisdiction over crimes would be linked with coverage of a national person, nationality tests, or territoriality as regards what happens here on this territory. But today we're trying to look to a broader spectrum of jurisdiction, which might be called universal jurisdiction, whereby this country might cover misdeeds outside the country, but to be prosecuted here. Now, the broader perspective of universal jurisdiction would be to cover any acts outside this country, anywhere, even not affecting our nationalities and territory. That is the broader universal jurisdiction. But the slightly more narrow understanding of universal jurisdiction, which is actually a personality test, is to say, look, if something happens outside this country, but it affects someone here, or if something happens here, but it affects outside the country, persons and territory outside the country, that personality angle can give rise to jurisdiction here to prosecute those crimes with an extra territorial effect. That can also be explored as part of a more modulated, so to speak, understanding of universal jurisdiction. In fact, a more personality test. Whatever the breadth of this jurisdiction, it is very important to try to cover misdeeds of an international import. In other words, mass atrocities, war crimes, crimes against humanity, genocide, and crime of aggression. With that in mind, let me invite you to look well to good discourse, good debate. Look to the future as we build a sense of humanity in promoting respect for humanity in war, especially when humanity, and now even non-humanity, might also be at war. And there is no better cure than prevention. And to see international humanitarian law and international law as a whole as a bridge to peace. IHL, international humanitarian law, is a component of the bridge to peace by enabling an element of humanity to remain, to be integrated, even in times of precarity, where the situation is precarious due to the conflict. And all this is a projection of hope in terms of our commitment to standards, norms, but to be complemented in reality by ourselves in terms of facilitating, enabling compliance, monitoring, enforcement, information exchange, as well as tracing of the victims and helping them here, there, and anywhere. That is the universalism of humanity through our very being in principle and in practice. Thank you.
Thank you very much, Professor Vitit. I'll make sure we'll send the clapping sound to him abroad. But anyway, that was a very powerful message by Professor Vitit, and it's very suitable to stir up, the academic discussion that follows this his very powerful keynote speech. Now, may I invite Ms. Margherita D'Ascanio, I'm sorry. For the Regional Legal Advisor of International Committee of the Red Cross, and she'll be moderating today's discussion. So I hand the floor to you now. No, you'll be, yeah, you can go now. All right.
Thank you very much. Welcome to all, and thank you very much for joining us in these discussions. I think Professor Vitit gave a very good introduction already to this panel, which is going to cover several topics. But what we would like to do today, together with you and the eminent speakers that we have, is to draw reflections on the state of affairs that we have geopolitically, and then draw reflections on the current state of affairs from a legal point of view, looking at international law and IHL today, and what we can do, each one of us in our respective roles, to enhance respect for IHL. And we will see that individuals actually play an important role. And then we're going to look at ASEAN and Thailand more specifically. So without further ado, I'd like to invite the eminent speakers that we have here to join me in the panel. I'll introduce them one by one. Yes, please. So we will start with Dr. Panupat. I hope the pronunciation is correct. Just a short introduction. Dr. Panupat teaches in the Department of International Relations, Faculty of Political Science in this university. He also serves as the Faculty Vice Dean for Academic and International Affairs. His research focuses on forced migration in particular, and refugee studies, atrocities preventions, and international conflict. He directs and co-founded the Center for Democratic Innovation, Human Security, and Atrocity Prevention. He has published in various journals, including the Journal of Refugee Studies, and works regularly with the Thai government on refugees issues. He was, in this regard, recently appointed as an expert member of the National Committee for Thailand's National Screening Mechanism. Please, Dr. Panupat, the floor is yours.
Shall I start right away also? Thank you so much for having me joining this panel today. So first of all, thank you to the ICRC and the Faculty of Law for having me today. And I just have to have some disclaimer because of, it's quite frightening to be here actually because I'm the only person that perhaps is not a lawyer on the panel. And in fact, I'm a sociologist, also teaching in international relations. Yeah, so it's a great pleasure for me to actually joining the panel today, and so that as much as I could share. I hope that I also learned from all of you as well. Before I proceed, I just have one major caveat that I would like to explain and express, which is the use of my language. Because I'm from the discipline of international relations and the study of law in the way that international relations scholars often do, there are some certain terminologies that really subjected to the debate for us. And then when I use the terms, for example, institutions, I'm not referring to, organizations per se, but it could mean the body of legislations, norms, and so on and so forth also, and practices. And sometimes I also use the term norms interchangeably with the term principles in the context of international law. And with this caveat in mind, I do hope that my exchange is still going to be relevant and to what we're talking today. So what I'm going to be starting today with is about the IHL itself and also the geopolitical situations within the regions and how it's its relevance to the discussions for today. And in the past few decades, we have seen the risings of armed conflicts in multiple parts of the globe, which greatly affect millions of people. And you can see from what Ajahn Vitit already mentions early on that it's been a grave concern for multiple countries around the globe at the moment. However, what I think is also important to understand the IHL or situated in the context of international politics is that the landscape of conflicts around the globe have been shifting greatly in the past few years. From international conflicts that used to be widespread in the past with the bordering of the nations and then the drawing of maps and so on and so forth. Now we are moving more towards the communal and also local armed conflicts. And then also we see more conflicts that occur not between states, but actually conflict between states and unstate actors, including the terrorist organizations and some others, as we have seen now today. So when we talk about the IHL, I think that it's really important that we have to recognize this changing conflict landscapes. And in the context of that also, we also have to recognize that international politics plays so much role, particularly with the relations between great powers and also geopolitics. So this is why, for me, the real key questions of the panels today from the political science and also sociological point of view is to focus more on the applicabilities of the IHL, particularly in the context of the non-international armed conflicts that the landscape has been shifting. And when we look at the IHL from the lens of international relations, I think that the topic that I would be expanding, it's going to be focusing on law and politics, and at the same time, it's the politics of IHL itself. And so I would like to establish clearly that, what I'm going to be investigating and giving my view will be focusing more on how IHL is operating under the purview of international politics. So when we study international relations, historically it's been a study of war and peace and something in between. And as Ajahn Vitit mentioned, when IHL is establishing and it got established, it's something that emerged in attempts to bridge to peace. But IHL at the same time, we have to recognize that when it comes to the emergence of it, it was an attempt to balance between humanitarianisms and also the military necessities. It raised specific questions of proportionalities, and in fact, it is undeniable that at the beginning, it also aims to protect what the state seen as the most valuable assets, and that is the combatants who have been injured and also wounded. And indeed, that it's also in the interests of the nation states. Thus, IHL itself is a product of international politics among nations. And it was then only in the late 20th century that the concepts and IHL itself become something that turns to protect more civilian targets. And this is a time when the interstate warfare actually declined. So you see that the conflict landscapes become something that really affecting how the operation of IHL to a large degree. So, and actually IHL has become something that really specify its legal protections in the original conceptions and design. IHL applicability has also depended on the type of armed conflicts, and also the protections only happen in a certain type of wars. And it was also later on, when in the context of the non-international armed conflicts, that it was included, certain groups of people. IHL thus, to me, from the point of view of international politics, is always one of the steps behind in order to curb what's going to happen and so on and so forth. So when it comes to the question of the national priorities, we really have to discuss about this context to begin with. So what does it mean also though is that and there is also the ordering of the conflicts that matters. And that's also the hierarchy of the legitimate violence that has always been discussing when it comes to IHL. And for me, as well as several international relations scholars, and to quote one of the professors from the political science department at the University of Minnesota, in quote, the IHL actively produce, protect, and privilege particular identities and agendas, and thereby producing and defending particular hierarchy of social order. And in this case, that's why, like the major power dynamics in global politics become something that matters so much in considering about these situations. But despite saying so, I'm not saying that IHL is not working. What I'm saying is that IHL is in fact a work in progress with its ongoing contestations and also constant negotiation. It always is contested with the multiple layers of agreement and also politics to achieve its ends. And thus, eventually, IHL become a matters that related to the balance between, as I mentioned early on, humanitarianisms and military necessities. It's a balance between the pursuit of war and the protection of its participants, but at the same time, it's in the attempt to balance between the curbing of the destruction and the security of the populations. And saying all this, what I think I would delve into more now in the second part of my discussion specifically is going to be on geopolitics. I would like to give you a landscape on how it related to the regions. It's a question of the proportionalities and the question of sovereignties and the production of IHL to make it priorities in the national agenda. So let's consider geopolitics. Geopolitics in the regions, particularly if we talk about this in the context of Southeast Asia, we see that it becomes something that is really scary in some sense, because we see contentions actually happening mainly because of the major power competitions trying to expand the area of influence. The concepts that we even using in the past few years, for example, Asia-Pacific, has now turned into another concepts, for example, Indo-Pacific. These different terminologies that has been used, also reflecting the way in which the states, particularly the major power, are conceiving of the regions geographically. So what could be the scenarios that are happening in the regions? There are quite a few, right, in relations to armed conflicts. One, direct conflicts between major power. Of course, this could be a possibility, even though it could be far-fetched, but still, it's in the realm of possibilities, particularly between the US and China. And that we can see that there's a rise of that contentions in multiple fronts already. Second, the conflict between major power and the middle power. And this conflict could be in some ways related, it's still in the state level. It's a conflict that these major powers might have towards some countries within the region. Like, for example, it could be a small incident that could escalate into war and major conflicts. Or third scenarios is also could be a proxy war that can actually happen by other states. And this actually can happen in the non-international setting, which means that, for example, certain groups within a certain states can break out and fight against each other in some contexts. And we can see this more clearly that, in some contexts that are so volatile, like for example, in Myanmar right now. This is a kind of thing that started to be seen as, like perhaps a proxy war between the conflicting parties in the domestic level. And last but not least, it could also be the communal conflicts, particularly within the certain communities and so on and so forth, that could eventually escalate into the level of civil war and so on and so forth. So if we think about it, that these are the scenarios that could be possible, what we're going to see is that geopolitical hotspots, particularly within the regions, become the kind of thing that are going to be really important. And the contestations between this could be seen from, let's say, Southeast Asia, right? We see the context of countries, like, for example, in Myanmar. I just want to give one quick example. Since the country is descended into the civil war already, as we've seen in recent years, we also see that major powers also try to influence what happening inside the countries. There are the emergence of new groups within the countries, and also what we can see is that both major powers, including the US at the same time as China, also develop certain strategies and initiatives for this fighting. For example, in the context of China, we see something called a Global Security Initiative. In the context of the US, we see the rise of the Burma Act of 2021. And these different mechanisms become the tool for the geopolitical challenge, within the region itself. But then when it comes to all this, how are we going to locate, all this geopolitical influence into the context of the IHL? Because of the influence, of course, that's about politics. But these politics influence the way that the fightings are actually happening on the ground. And that affects, certainly the civilians and the emergence of civilians and some other groups. One of the key questions that I think it's really important for us to discuss now today is also of how to identify civilians. Because of one of the ways or one of the key groups that we have been seeing or emerging in recent years is that it's the groups of people who could be both civilians and combatants at the same time. What is the line to be drawn? For example, in the case of Myanmar again, we see the rise of the People's Defense Force. And these People's Defense Force, or the PDF, they are random farmers on the ground. But then they are the ones that simply just, take arms now and enter into the fightings against the armed forces. In such a case like this, how would we define the situations of them as such when they hold the grudge against what's happening on the grounds based on what the government has done to the people? So in such a case, it's become the situations that the line to draw between the civilians and also the combatants become unclear. So for these reasons, this is a kind of situations that are actually happening. And how would IHL be relevant in that particular context? Second, we also seen that in the context of the protection of civilians, as Ajahn Vitit mentioned early on, it's related to the nexus between the IDP and also refugees. Of course, IHL itself doesn't govern the refugees specifically. But in this context of protection of the civilians, it also leads to the protections of the IDP who are seeking refuge in some of the internal zones inside the countries. But what happened is that we see the situations in which there was the destroy of the logistical routes to go into this area of support. The case or the incidents where the areas where they have been seeking refuge has been damaged. The destroy of hospital, the destroy of school, where some of these people be able to actually stay and remain having normalcies in their life. In such situations, the protection doesn't happen because of most of the times, the conflicting parties do not regard the IHL as a mantra for them to take actions. So the key questions for me is what exactly is the hurdle and how we can overcome it. So this will lead me to one of the maybe last point that I would like to make before I hands on the discussions to some other panelists. It's what I would refer to as the trap of sovereignties, and which is so difficult for us to actually get back up. Sometimes when it comes to the discussions about IHL, we also have to understand that the term international humanitarian law, it's in fact international. It's between nation states. And because it's the discussions among nation states, the ideas of sovereignties become something that's still enshrined in these discussions, which is and sovereignty, the principle of sovereignty either as a norm or as a principle itself, is also considered to be one of the most successful international principles and also in the international affairs. But there are two dimensions to it. One is the sovereignties that is internal, and another one is the external sovereignties. So curbing the international warfare, of course, that's to focus on the external one. But when it comes to the internal one, like the situations I've been discussing, like in the case of Myanmar, for example, how exactly would IHL be able to actually overcome that obstacle of the international sovereignties? Because we have something to do with the notions of, for example, non-interference, but what exactly would it have to do, right? We have some ground in which some kind of interventions could happen. For example, the conceptualizations of R2P and the establishment of a norm for the intervention to protect civilians. But again, where is the gridlock? It's also go back to the P5 and also the security councils as well that are dominating in some regards. So the question is, if we were to overcome this sovereignty trap, and make the IHL become the national priorities, it's really important for me to actually mention these few things. Number one, it's the significance of shifting the focus, particularly the geographical, the geopolitical and geophysical and geographical focus of the IHL body to be at the regional level. The reason why I'm talking about this, because of this will allow the development of IHL in the way that's more relevant to the conflict dynamics and the nature of conflicts within the certain regions. And that perhaps allows peer pressures to actually happening. Second things, one of the successful elements of IHL that needs to be extended more is a tribunal and also the spatial court. And I think this is some kind of thing that needs to be expanded, to cover, but in the context of the regions. And also the whole process of documentation, which becomes something that's going to be really important. But what elements of IHL should be prioritized? That also some things to actually need to be discussed specifically. Because for the states to be able to accept or elevate the IHL to become something of the national agenda, it requires the so-called political will. And for the state to have that political will, it requires a certain elements of the IHL to be prioritized. The last but not least, and the key important questions that I would like to actually mention is that one of the things that we may have to consider more is that now when it comes to the contestations and the armed conflicts, there are certain areas where no states, not even the government in charge or claim to be in charge, can really maintain the control. Can those areas be the areas where the IHL actually operating once the power is actually in vacuum, so that the protection of civilians could be more effective in that sense? And this is happening, for example, in the context of Myanmar, for example, that we see that the areas where the current military is controlling, the regime is controlling, is shrinking to 40%, while the rest of the country is actually controlled by some other groups. In those 60% of the areas across the countries, is it possible that IHL could actually be operating so that the protection of civilians can actually be conducted? And now if we talk about this perhaps in the context of Thailand as well specifically, I think that there are lots of opportunities that we can think about the application of IHL in the context of Thailand, because with regards to the national security agendas that actually already been released out in the past few years and so on and so forth, and that's going to be in operations for the next 5 years. What could actually happening is that perhaps the prioritizations of the IHL could actually be done in together with some establishment of other norms, international norms that actually could be the highlight. So through some of the, for example, the focus or the shifting of the terminologies and so on and so forth, that could be something that the IHL could be adopted. Perhaps not through the exact word of IHL per se, but perhaps it's through some other related conceptions. And that's, again, it's come down to the agreement and politics and the negotiations between the states and international law, which I think is a classic contentions that always happen. And perhaps the agendas for the prioritizations of the IHL, certain countries in the regions could be the one that really take leads. And that countries, I think that Thailand in recent years could play a greater role more in this regard, particularly through ASEAN. Because if we look back into the history of what Thailand has been done in the past in resolving conflicts, for example, in our neighboring countries like Cambodia, and play a part in the breaking some of the deals together with some other countries like Singapore and so on and so forth, by joining hands together with them, that could be a possibilities for the IHLs to actually be honored and respect and prioritized in the regional context and also in the national context. Because of sometimes when we talk about this in the context of the multilateral organizations, it's difficult for IHL to be prioritized. The reason why, because of states do not see the priorities in their own context. But when we talk about it in the regional level, that's when IHL could be see clearer how it's related to them. And I would like to end it there. Thank you so much.
Thank you very much, Dr. Pannappa. That was, I think, an excellent overview of the general picture in which we live today, and indeed the interaction between international law and international relations, and how the first plays also a role in relation to the implementation of the second. After this international relations picture, now I would like to invite another eminent speaker to give the international legal picture. It's Raul Pangalangan, who is probably very well known to many of you. He is a former judge of the International Criminal Court. He is currently professor of law at the University of the Philippines, where also he served as a dean between 1999 and 2005. He has lectured in several places, including the Hague Academy of International Law. He has held visiting appointments in Harvard, Melbourne, Gong universities. He received his LLM and SJD from Harvard University and his diploma from the Hague Academy, where he taught. He has been elected to the Institut de Droit International and was a member of the Permanent Court of Arbitration. Thank you very much, Judge Pangalangan. The floor is yours.
Thank you so much for the kind introduction, Margherita. And I'm happy to be back here at the Chula Longhorn to speak. Thank you for inviting me here. I would like to pick up 2 points that my friend Professor Vidit Muntarborn mentioned earlier. The first is his call for us to look at IHL within the larger framework of public international law. And I will do that by looking at the norms of IHL and the way they are enforced through different enforcement regimes. And I will I will contrast the application both from individual criminal responsibility on one hand, and on the other, state responsibility. And the other call of Professor Muntarborn is he noted the limited Asian ratifications of the Rome Statute, and in general, what has been called by the former dean of the NUS Law School in Singapore as the Asian ambivalence to international law. So let me proceed. I will deal with actual cases. Look at the way the conflict in Myanmar was treated by different tribunals. At the ICJ, the International Court of Justice, it deals with state responsibility. And what was the case filed at the ICJ? It was genocide, a very frank recognition of what is happening with the Rohingya. But note a few things. The first is that the complainant was not even from Asia. It was the Gambia, from Africa. Filing an application before the ICJ on the systematic destruction of villages of the Rohingya through mass murder, rape, and other kinds of sexual violence. What within the IHL framework we will consider as crimes against humanity. The second is that if the applicant was not even from Asia, it is significant that the respondent is actually the state of Myanmar, despite the fact that today, after the coup of 2021, it is now governed by the military regime, which has not been recognized in many places. And as was mentioned earlier, which is not even in control of like roughly 50%. I think your figure was 60%, right? 40%. Yes, of the territory. And so they can very well complain. You don't recognize us as representing the state, and yet when you want to blame someone, you look at us. So there is that angle. And of course, the straightforward responsibility is the treaty obligation pertains to the state of Myanmar, but they are an organ of the state, indubitably. That's straightforward under the International Law Commission's Articles of State Responsibility. It is attributable to the state, and therefore they can be held responsible. But most significant, the offense which is implicated is that of genocide. Contrast that to the treatment by the ICC, my former court, I was a judge of the International Criminal Court, former president of the Trial Division, former president of my own trial chamber. At the ICC, the prosecutor is investigating exactly the same thing, the offenses against the Rohingya. Do we call it genocide over there? No, it's not. The crime charged before the ICC is the crime against humanity of deportation across the Myanmar-Bangladesh border and of persecution on grounds of ethnicity and or religion against the Rohingya population. Why so? Because the court, the ICC, has no jurisdiction over Myanmar. Myanmar is not a member of the Rome Statute, the founding charter of the ICC. But the next door neighbor, Bangladesh, is a member of the Rome Statute. And therefore, the court can investigate only crimes committed in Bangladesh. And that crime is the crime of deportation because the crime is completed the moment the Rohingya cross the border into Bangladesh. So notice, this is not to make light of it, this is a jurisdictional game familiar to anyone who has taken part in the moot court competitions. As some, who's the coach here, can very well tell you. The jurisdiction before the ICJ is based on the compromissory clause under the Genocide Convention, and therefore the case has to focus solely on genocide, because that is the only offense, over which the court acquires jurisdiction under the Genocide Convention. Conversely, for the Rome Statute, the only crime, the only state under the court's jurisdiction in this case is Bangladesh, and the crime which was completed on Bangladesh territory was that of forced deportation, and therefore not the crime of genocide, which would have been committed in the territory of a non-state party, which is Myanmar. So notice the characterization of the offense committed depends upon the jurisdiction of the forum which is hearing the offense. And in the modern approaches to international justice, this is called the problem of fair labeling. The label is not accurate. And for the victims, part of the justice that they want is that the label must be accurate. It must reflect exactly the crime that was committed to them. This was best articulated in the many cases on the comfort women after World War II. The war crime committed against them typically would have been slavery. And as slavery, that would be Hugh Scoggins. But the victim said, look, if you just call it slavery, we are no different from prisoners of war who are forced to build bridges and to repair roads. And they said, the multiple rape committed against us every day for 3 years, 4 years, goes beyond merely slavery. It is of an intimate character, and it should be called sexual military slavery. The lawyer's response was, the moment you venture beyond the term slavery, you lose the Hugh Scoggins character of the offense. But anyway, just to jump to the end, the solution was to say that the crime is slavery, and the words sexual and military are adjectives, just to satisfy both the demand of the lawyers for a strict legal framework and the demand of the victims for fair labeling. I now go to another conflict, that of Ukraine. The global response in international law was rather impressive. It was very robust. The UN Security Council was paralyzed by the Russian veto. But the UN General Assembly still managed to call an emergency session by invoking a 1950s resolution, the Uniting for Peace resolution during the Korean War. and saying that if the UN Security Council, because of the veto by the permanent members, is unable to act, then the General Assembly can step forward, still with a non-binding resolution, but still call for action on Ukraine. And they managed to do that. The thing is, before the ICJ, we are back to the same problem that we faced with Myanmar. The jurisdiction before the ICJ is tightly regulated, and here they invoked as well the compromissory clause under the Genocide Convention, basically saying that any dispute under the convention will be referred, can be referred to the ICJ. But look at the unique thing here. Ukraine was invaded by Russia. The Russians saying that Ukraine is violating the Genocide Convention because it is oppressing the Russian-speaking populations. So Ukraine goes to the ICJ, not because it is complaining that Russia committed genocide, but a rather unorthodox measure. It's asking the court, hey court, can you tell the Russians we're not committing genocide? And even if we're committing genocide, they're not entitled to invade us, to launch a full-scale war. So again, notice the creative use of international law here to seize the court of jurisdiction. But the other significant thing is that 33 states have filed interventions before the court to join in solidarity against the Russian invasion. And going to the theme with which I will close, Asian states are barely present in that list of 33 states. The same thing with the ICC. The prosecutor said he's going to investigate the crimes in Ukraine, but it will move faster if he has state referrals, because without a state referral, he will need to go to the pretrial chamber and ask permission to proceed with the investigation. But with a state referral, you streamline the process. It's fast forward. And within a matter of less than 2 weeks, he had 43 state referrals. Again, with very little Asian participation. Significant also is that when he finally issued a warrant of arrest against Putin, it was not for the crime of aggression, which is widely recognized as the crime which was committed with the Russian invasion of Ukraine. Not for aggression, not for war crimes, but solely, not for crimes against humanity, but for the war crime of unlawful deportation of children from occupied areas of Ukraine to the Russian Federation. And again, we have the problem of fair labeling. Of course, the crime of unlawful deportation, that is the kidnapping of the children, is a crime, but in terms of the gravity and the scale, way below that of aggression. Okay, I now proceed to the irony of the ICL treatments of these issues. And the moment we shift to international criminal law to advance classical IHL prohibitions, we actually are, sort of trapped within the framework of criminal law. So the irony is that when human rights is mentioned in international criminal law, typically it's not the human rights of the victims, not those who were killed, not those who were raped. It is the human rights of the accused, the unsympathetic, unworthy, homicidal, genocidal accused. In other words, it is the right of the accused to be presumed to be innocent until proven guilty before a court of law, in accordance with fair trial guarantees, and the standard of evidence is very high, proof beyond reasonable doubt. When we look at the crimes, the first question is to ask not just the jurisdiction, but also the attribution. You have to link the accused to the crime. And finally, on this point, the problem that, especially in one case, the problem when IHL standards are different from ICL standards. In the Nataganda case, the accused was charged with having raped his own child soldiers. They will recruit, they will kidnap boys and girls. Typically, the boys become soldiers. The girls become, forced wives. And in this case, they were raped. His defense, under IHL, I committed no violation because a war crime has to be committed against the enemy party. Well, I raped my own soldiers, he said. That's not covered by war crimes. The response of the court, and I took part in this decision, is that, well, sure, if you apply the customary law of IHL, that is the effect. But in our sources of law, the first law we apply is the Rome Statute. We don't make that distinction. And I will explain later the dynamic here. And the court proceeded to convict this commander for the rape of his own child, of his own soldiers within his own army. The next, and this is a case in which I also took part, the notion of a battlefield attack. This is the landmark case. There was the head of religious police affiliated with Ansar Dine, with a radical Islamic group. He was destroying mosques which did not conform to his interpretation. And one defense was that, well, in academic articles, it wasn't raised in the decision, was the attack should have been committed in the course of the battle. And it shouldn't have been attacked when the battle was all over and it was just the cleaning up operations. Now, look, in the past, the destruction of temples was seen as part of the spoils of war. You know, you have won, and therefore the prize of the victor over the vanquished is to replace his, in Mexico, to replace the Aztec temple with a Catholic cathedral, or in Istanbul, the Hagia Sophia, to transform the Catholic cathedral into a mosque. So the destruction of temples was part of the cause of the war, the reason for the just war, and it was part of the jus ad bellum. But for us, we recognize the changing nature of warfare, and this is, of course, some will deal with the even more difficult elements of the new changes in warfare. But here, the destruction of the temples was not the end goal of the process. It was part of the campaign to destroy the will to fight of the enemy. The same thing with rape. You rape and humiliate the population so that they lose their will to fight. It becomes part of the jus in bello, squarely governed by IHL. So notice in the earlier case of the child soldiers who were raped, the ruling was that the attack must be committed in the course of the battle. But in the Almaty case, we said, no, it doesn't have to be committed in the heat of battle, because the nexus required by our law is to an armed conflict, not to a specific attack. In fact, the dissenters in Nataganda, in the other case, said that you're construing the nexus requirement too narrowly. How about cleaning up operations? And you can't even draw the line very clearly between the moment of triumph and the moment of the consolidation. Okay, by way of closing, my last 5 minutes. This all transpires within what has been labeled by Professor Chesterman as Asian ambivalence to international law. The lowest participation among all the regions of the world in the Rome Statute, the weakest responses in all the solidarity measures in the Ukraine crisis. And the usual explanation is the anti-colonial explanation, that these are former colonies, they don't have to deal with these Western impositions. When the Philippines was being investigated by the Rome Statute, he said, I will not be tried by a court consisting of white men. And some newspapers posted the picture of the court. The president was from, at that time, was from Nigeria, and the prosecutor was from the Gambia, telling him like, well, Your Excellency, they're not all white men. I was also there, by the way, so in that picture. So, but that is the resonance of the anti-colonial argument. But you know, I have an entirely different take. The Asian hesitation to deal with my former court, the ICC, is less because we are international, but because we are a court. I think it is the Asian reluctance to submit in advance to a binding third-party resolution of disputes based on rules. And I think the other problem is not just a cultural thing. It is that Asian states see the ICC as no different from local courts. If local courts are corrupt, they assume that the international courts are also corrupt. If local courts are vulnerable to pressure from the local politicians, they think that international courts are also vulnerable to such pressure. I have tried my best to explain that we are different. And just recently, I tried an entirely different tack to show how different our court is from local courts. You see, in the Philippines, the highest justices, the highest judges, move around with bodyguards, and they have a backup vehicle behind them. They have a trained chauffeur to drive them. I tell them in the ICC, I ride my bicycle to court. And I imagine in most of Asia, it is completely unthinkable. Well, of course, in Philippine weather, if I ride a bicycle to court, I will be very sweaty already by the time I get there, and might even get run over by vehicles that don't respect the rule of law on the roads. But for me, that is why, back to one of the themes of Professor Buntarporn, perhaps the campaign to strengthen international regimes to enforce rules should start with strengthening domestic regimes, domestic measures for the rule of law, not just in terms of institutions, but also in terms of normative discourse. In Asia, there are very few ratifications, but Malaysia almost ratified. And actually it signed, and then it backtracked. Oh, the same thing. Yeah. Oh, I didn't realize. I should check up on that. Apparently Thailand also signed. But you see, it's rare that the signature is based upon a normative consensus. It is based upon the balance of powers among those who are entrenched. And all it takes is for one power player to back out, and then the whole thing collapses. So, but that is a larger anthropological project, which is the place of normative discourse in Asia. And I think it's easier to just focus on strengthening domestic institutions for the rule of law. Thank you so much. Thank you.
Thank you very much, Dr. Pangalangan. I think we can, you articulated a very complex discourse, and perhaps to summarize it, and very interesting and pertinent, I think the key message is really an important one. But just to summarize it, maybe in a few key points, if you allow me, and feel free to correct me. But I think you pointed us all to the constraints, actually, of the fora in which international law is brought. And the importance, actually, of who is involved as a party in that fora and how it shapes, actually, the narrative and international law. And therefore, the importance that all, actually, we participate in those fora, in the creation of those fora, to ensure a full development and endorsement of international law. The importance to separate, actually, law between law and politics, contrary to what our first speaker was actually pointing out, but those are simply two perspectives. But as lawyers, we need to monitor the faithful implementation of the law. It's the only objective instrument that we have. And indeed, therefore, a way to all participate and contribute to international law is to strengthen our domestic systems, because that's where actually we first and foremost take a step in the clarification, enforcement, and implementation of the law. So thank you very much. And without further ado, now I'll pass the floor to my colleague, Andre Smit, Regional Legal Advisor on Maritime Matters at the International Committee of the Red Cross. He's also part of the Regional Resource Network for the Asia Pacific, a team of experts for the region based in Thailand. His previous work includes practicing law at the South African National Defense Force Unit. He taught at several courses at the university level. He offered his services also to the Foreign Ministry, to the Ministry of Foreign Affairs in South Africa. He is admitted to the High Court of South Africa as a legal practitioner, as attorney, and later as advocate. Thank you very much, Andre, for joining us. The floor is yours.
Thank you, Margherita. Good afternoon. Thank you so much to Chulalongkorn University for the invitation and the privilege of being here, and to my colleagues for making this possible. I certainly feel very excited to have been able to hear the previous speakers speak, and I think my contribution is much more humble and I think less ambitious, but I do hope it will contribute. My contribution today can be summed up in two words: to plan and to practice. To plan and to practice. And our topic today centers around how can we empower, better enforce this branch of the law. How can we, should be elevated to a priority, elevated as a priority. So again, reflecting on those two words, plan and practice. We can empower and better enforce this branch of law through simple planning and practicing. And to show you how I arrived at that bottom line, I'm just going to invite you to go on a short journey with me in my own military career as an operational legal advisor in South African National Defence Force. Firstly, on plans. I spent many an hour listening to operations being the intent of the commander being conveyed, operations being planned, commenting on military plans in exercises and operations, and many an hour in after-action reviews, thinking what went wrong when there was an incident. And there's, so on the first point, on planning, there's two things that I took away from that. The first is, no plan survives contact with the enemy. You might have heard this in various iterations. I think even Sun Tzu is known to share a version of that. But I think von Moltke in the 1800s is most famous for penning this in a paper that he wrote. No plan of operations extends with any certainty beyond the first encounter with enemy main forces. Mike Tyson said it like this: everyone has a plan until you get hit. I think that's true for Muay Thai too, probably. Now, so you might say that's, you know, what is your point about planning? I'll get to that. The second thing that's important in relation to planning is this. No one survives without a plan. The plan might not survive contact with the enemy, but no one survives without a plan. And I think General Eisenhower, who led the Allied effort in the Second World War, invading Europe with D-Day, said, in planning for battle, I found that plans are useless, but planning is indispensable. So again, reiterating that the plan itself might not actually work out as we thought, but without the plan, we are dead. So I want to illustrate this with a very simple example. A military unit is given an objective. They have to advance to a certain point, and they will have to cross a river in doing so. Now, the planning is simple. The planners will have to assess what is needed, and this unit would probably need an engineer battalion for them to be able to cross the river. In this kind of scenario, they will only use the engineers if the bridge is blown, because usually there's a bridge to cross the river. So as it happens in my example, they do advance, they have an engineer battalion, they get to the bridge, and upon contact with the enemy, the bridge is blown. They cannot cross the river. Because they planned, they are now able to set up a temporary bridge and cross a river. So the plan itself was to cross with a bridge, but the planning had contingencies in mind and possibilities that might arise, and they had the equipment necessary to perform that. Now my point is this: if militaries accept this principle of planning in achieving military objectives, why should it be any different when trying to achieve military legal objectives, which would be to comply with IHL? And I'll come back to this. I think on practicing, of course, in practicing IHL, there are prerequisites. There has to be dissemination, proper instruction, implementation, not only in legislation and policies, but in military manuals, in instructions, in standard operating procedures, lower down. This, of course, there's a commander's responsibility, but I think at a state level, the obligation of teaching your military what the law requires, implementing those requirements in laws, regulations, instructions, orders. There's deeper levels of implementation than that, because those are the things we usually speak of. But the deeper level of implementation, I would refer to a psychological or maybe even a physiological level of humanness. It's very practical. Speak to psychologists, educators, dog trainers, parents like myself, and they will all probably tell you conditioning and repetition is essential to learning. And I think sitting at a university today with so many professors, I hope that they will not say that I am speaking nonsense. But what I want to say is, it seems to me that repetition is a major part of learning. In fact, what I could see is that the most important factor in conditioning or learning might be repetition. I can't stand here and say, or sit and say repetition is the answer to everything. Certainly, there are other factors too. But what I want to get to is a military should internalize IHL. It should become second nature. Again, I will try and illustrate that. When I was in the military, I was given an assault rifle and trained to use that assault rifle. Now, you learn a lot of things. Assemble it, disassemble it, clean it. Assemble it with a blindfold. When there's a stoppage, clear the stoppage. Charge, aim, make it safe, etc. That's a very basic skill for an infantryman. Yet it illustrates the purpose that is done again and again and again. If an infantryman in a combat situation encounters a stoppage in his weapon, it ceases firing for some reason, there's a drill that he immediately performs. And that usually solves the problem and he can continue fighting. If he doesn't do that, there is a chance that his weapon would not work and he will be killed. Ironically, maybe an enemy would still live. But from your own military's perspective, you could save your own military's lives by knowing your stoppage drills and executing them after you've practiced them until they become automatic. That is standard for almost all militaries that I have seen and I've worked with. It's indispensable for achieving success. Now, again, I will ask the question, if that is standard operating procedure for militaries to practice things again and again and again and again until it becomes internalized, why is it any different for us when we speak of IHL implementation? Should it be any different? Of course, my two P's, planning and practicing these things, relate to the other questions of today as well. I think that compliance becomes real if it's planned and practiced for. Compliance is actually secured long before an incident occurs. Prevention is aided by proper planning and practicing those drills. I'd like to, I think, also echo what was said in the keynote speech. Prevention better than cure. Very much supported. If we do these things in peacetime, when there's no political sensitivities, when we actually have the space to clarify the law and to implement it as is, it's the best time to do it. And there I must go back to Common Article 1 of the Geneva Conventions. which obliges high contracting parties who undertake through that to ensure respect for the present conventions in all circumstances. Now, that has been clarified over the years. The commentaries are very useful, but that commentary really reflects state agreement. That has been clarified over the years to include what we do in peacetime, what we do before there is an armed conflict, and what we do not only as a state in terms of our own armed forces, but as states vis-a-vis one another, especially thinking regionally, ASEAN, or having regional partners or even military allies. What are the responsibilities of a state under international humanitarian law to implement these things in peacetime, but not only on its own military, but encouraging and, if you read the text, ensuring respect also by allies and partners. So I think going back to my own career for a moment, I certainly had soldiers coming to me after a lecture saying, it's very nice that you say we must treat prisoners of war with respect, but if I catch a enemy combatant who just slaughtered my compatriots, this stuff is not going to fly. And my answer would be the same to them as it was always to commanders. I'll go back to the stoppage drills. This isn't something that we debate. What do you do when you get a stoppage drill? You clear the stoppage. What do you do when you have an IHL problem? I would love to see those military units to have planned for it and practiced it again and again and again. So when I capture a prisoner of war, I know exactly what I'm going to do, and I have my steps, and that includes treating that person with the due protections and other aspects like recording the information that's needed and transmitting that if it's a higher echelon in the military. Those things must become automatic because in the heat of battle, we cannot debate how are we going to treat a prisoner of war. You cannot win the debate there. You can only win the debate long before if you have time to really explain these things and why it's important. Now, it would be remiss of me to as a regional legal advisor on maritime matters, not to go to maritime, which I haven't done up to this point. So let me do so, but I'm going to use the same principles, planning and practicing. And I'll use that now at the strategic level, not at the tactical level. At sea, what can we encounter, or what can we expect to encounter during an armed conflict at sea? That question is a burning question for academics now, because there is such little state practice since 1945 on armed conflict at sea. So I do hope there will be some interest in the room even in that. And for Thailand as a maritime nation, I think in particular, but with the geopolitical tensions in the region, it's certainly a very live topic. Let me make it practical for Thailand first. Is Thailand expecting certain things? And are they planning to address those things? And that I will not state as a belligerent. I think I would like to focus today just on a neutral state. If you're a neutral state, there is the danger that you might say, I'm not going to fight a war directly, so what do I need to prepare for? I'm actually at the political level just trying to avoid conflict. That is a very dangerous position to take because there are very clear obligations, even for neutral states, middle powers that are sometimes wedged between competition by stronger powers if there is an armed conflict at sea. These responsibilities of neutrals, of course, are triggered when an armed conflict takes place at sea. Now, there is of course, other bodies of law applicable, particularly treaties on maritime search and rescue that might co-apply. There is the law of the sea that remains applicable. So one of the bodies of law that is also applicable with international humanitarian law, the law of neutrality, and as it's applied at sea, maritime neutrality, if you want. And for a maritime nation, those are very important questions. Separate yet complementary legal frameworks, the law of neutrality, at least in part, having the same object to minimize, mitigate the adverse effects of international armed conflict. Now, law of neutrality regulates the relationship between states that are belligerents, parties to an armed conflict, and states that are not. And that relationship from the maritime perspective is very interesting if we go to the Geneva Conventions. And I'll just focus on the second convention, dealing with the amelioration of the condition of the wounded, sick, and shipwrecked of armed forces at sea. The word neutral mentioned 40 times. It refers to neutral powers, neutral countries, neutral states, really as interchangeable topics. By referring to these terms, the 1949 Geneva Conventions, and I think in terms of what was said already today, specifically acknowledged, for the purpose of humanitarian law, continued validity of the law of neutrality. There cannot be protecting powers or so many mention of neutral states and neutral obligations without the concept of having neutrality present in armed conflict. Now that is of course a much greater topic than what we will have time for today, but I think something that we can take from that is 1949 was after the adoption of the UN Charter, and in particular the argument that you will hear in terms of neutrality today is how it was modified by the UN Charter and the outlawing of war. So that is definitely an argument to say, well, neutrality is alive and well. It might not look like we thought it did, and we'll have to talk about that. But there is definitely a conclusion that neutrality is a concept that is still very much there and very much at sea. Now, I will conclude with some of these remarks. About neutrals. Neutrals are obliged to apply the Geneva Conventions by analogy in many cases. So what does that mean? If I'm a belligerent, country A fighting country B captures prisoners of war, combatants from country A, there are certain conditions of treatment stipulated in the Geneva Conventions, third convention in particular. If I'm a neutral and I capture or I take control over members of the armed forces of a state that's engaged in an armed conflict against another, by analogy, the methods and the rules and standards that I'm going to use to treat them is going to be the same ones that I would have used if I were a party to the armed conflict. So just giving an example of by analogy, what does that mean? You're not a party to the armed conflict, yet it's very important to plan for the possibility and practice it so that when the time comes, these things are ready to be implemented. I will give some more examples. Article 15 of the Second Geneva Convention provides for wounded, sick, and shipwrecked being taken aboard a neutral warship. What does that mean? What are the requirements there? If I link that with Article 17, belligerents landed in a neutral port, there are obligations on neutrals that they have to ensure that those combatants that belong to the armed forces of belligerents will not take part in the conflict for the duration of the war. What does that mean? Article 18 refers to the searching function after armed conflict at sea to search for and collect the wounded, sick, and shipwrecked. If you look at Article 21, it speaks to the fact that there can be calls made to neutrals to assist in this function, particularly on collecting the dead. That's an obligation for a neutral state. Are we considering this? Are we planning to encounter this? And are we actually practicing this in the sense of what are we going to do, and do we use that in exercises? There are more, and I think for time I will not state all of them now. Anyway, I started with the tactical level, plan and practice. I think at the strategic level, nationally, regionally, because this can be done at a regional organization. This can be done between allies. It's not only for one state to consider. But are we thinking of the future, what we can encounter in an armed conflict? Are our navies or maritime law enforcement that might otherwise be involved planning for this? Are they rehearsing it? Just think of the simple question of capture cards once somebody is captured, and the reporting function, and how little navies actually are prepared on that. They're very good with piracy and rescuing migrants and all kinds of other things that they've done over the last 50 years. But very few navies have captured enemy combatants. I'd like to add with a quote that's usually misattributed, and people say it wasn't really William Burke who said this, but we all know this quote: all that is necessary for evil to triumph is for good men to do nothing. I just think I should add that I commend your university for doing this, your country for taking this so seriously, because I think this is doing something, asking the question, should we raise this as a priority? And this is that something that's being done. So I hope you will join us in raising that flag wherever you go to say we should raise this as a priority. My small contribution is, let's plan for it, let's practice it. It's not necessarily limited to the military, it could be academically as well. But very important for neutral countries, and very important, I think, for Thailand from the maritime perspective too. I will stop there. Thanks, Margherita.
Thank you very much to you, Andre. So indeed, the importance in peacetime to implement IHL. IHL applies in armed conflict, but there are some obligations that are actually meant for peacetime, and it's in peacetime that we need to prepare. And you highlighted how much also, and particularly perhaps in an interconnected world, IHL concerns us all. Neutral states have a role to play, have obligations actually. And it has been a while indeed that we were not speaking about naval warfare. And speaking about it, reminding soldiers what is it about is indeed part of our obligations. And that's very much in need, particularly in this region. Now, last but certainly not least, Professor Papawadi, lecturer on public international law and conflict of laws at the Faculty of Law of Chulalongkorn University since 2019. She has served as a member of the Board of Experts for the Asia-Pacific Journal of International Maritime Law, and we thank her very much for that. She holds an LLD with a specialization on cyber operations and the use of force from Kyushu University in Japan. She received her master's degree in European Union law from Université Paul Cézanne Aix-Marseille in 2011. Her publications revolve around the topic of cyber operations, as you may have guessed. One of those focused on the Tallinn manuals and the making of the international law on cyber operations. Thank you very much, Professor Papawadi.
Thank you very much for your kind introduction, Margherita. I think all the panelists has mentioned very key point of IHL in terms of international relations, geopolitics, and also the Asian culture about IHL applicability and also ICC. And also the practical level of how military have to be prepared for in case of any kind of armed conflict. So the topic that I would like to address, it's more challenging issues on IHL to protect civilian when the means and method of warfare involve cyber and digital operation. And it is not only the broad topic about how cyber operation can be defined as an attack in IHL, but more on particular the scenario that has happened recently, and the focus is on civilian involvement in such operation and how other civilian will be affected from that operation. So I will not go through the outline, but just go straight into the scenario. From this screen, you would see that this is what happened and reported in many news outlets in April last year, that Ukraine power grid luckily withstand Russian cyber attack. And from this point, you could see that there is a use of cyber attack as a mean in time of armed conflict between Russia and Ukraine. So, but look at another slide. I think this is in probably not long ago, last year, also November, that Microsoft has already declared that it will extend its IT support to Ukraine in armed conflict. So that armed conflict, you know, that is between Russia and Ukraine. So what kind of message that Microsoft say? Microsoft indicating that they're supporting in terms of defensive. So it means that Microsoft try to have a software to prevent cyber attack that attacking Russian power grid. So that is defensive idea that Ukraine wants to defend its own national critical infrastructures. But what about the case that support could lending to Ukraine fighting against Russia in this scenario? Another scenario is that Moscow Exchange Bank website was knocked down. So basically that was also a key economic website for Russia. And that was traced and was evident that Ukraine IT army was part of the attack. So in case that Microsoft engaged in this kind of attack, whether Microsoft as a tech company of neutral, I would say neutral state, I'm not quite sure whether it's qualified or not because Microsoft is under US law, right? And then US has supporting Ukraine in the conflict between Russia and Ukraine. But imagine Microsoft as a private tech company. So in this case, whether Microsoft itself, all the public cloud, so basically all the critical infrastructure of Microsoft becoming an military objective. So it's lose civilian objective or not. And another scenario, very scary scenario, is that look at this Twitter that Ukraine, you also see that Ukraine use a lot of Twitter messages. And from the message itself, it comes from this one, from Mikhail Fedorov, who is the vice president of Ukraine. So he said that he recruiting soldier, I would say soldier, because it says IT army, to be part of the IT army of Ukraine fighting against Russia. And all the soldiers will be communicated through Telegram. And how can this member of Ukraine were recruited? That is the question. Because anybody could also participate via Telegram and get instruction from that Telegram account. And whether if civilian become participant in this IT army of Ukraine, whether such civilian become soldier or become military or combatants or not, and whether such civilian lose protection. You have to seize the scenario of cyber operation that there is a lot of cases that the civilian who is hacker, they participating in cyber operation, cyber attack against another warring state during the nighttime, but the daytime they work as student. So whether these people become combatant all the time and can become a target on attack. You could see that the target of attack is far away because that person is at home. So how can Russian attack that person? But this is not only about civilian individual, but more about the infrastructure that would use by such person. For example, the server that the civilian using is also whether such server itself becoming military objective or not. And another scenario that is for me is very scary. This is an app called Basu app, and this app was in peacetime was used by Ukraine law enforcement as reporting crime. So basically, if you're on a peacetime before the attack in February last year, any Ukrainian who downloading this app and see a crime, they could take a picture, and this picture could reporting to police, Ukrainian police, and then so the police can come on time to rescue people. But this Basu app, after the invasion from Russia, it become a tool. May I read the description on the app, because this app available from both iOS and Android. So this app, it said that an application for disseminating information about location of enemy Russian equipment, soldier, and dangerous object on the territory of Ukraine. If you have witnessed the movement of enemy vehicle, aircraft, equipment, soldier, sabotage, and renaissance group, you could reporting this app. For it means that any Ukrainian civilian, they are living in their normal residence, they when they witness the movement of the Russian troop, they probably holding the phone and take photo and then send it directly to Ukrainian army. So such an action probably significantly contribute to the military operations of Ukraine. You know what? Because that directly reported to the Ukrainian army. So it means the Ukrainian army can ambush the Russian troop. So when we see this causation between the action just taking pictures of civilian and then that's sending directly and contributing to the military operations of Ukraine. So whether such action making that civilian become combatant. And this is quite scary scenario because you see that when you taking photo, imagine yourself as Ukrainian, you taking photo and Russian troop, Russian military saw you directly and then they could shoot you and justify as military necessity. That's one movie that I watched a long time ago. It's called Lone Survivor, if I'm not mistaken the name. And in that Lone Survivor, it's about story of a soldier fighting probably Taliban. And there's one kid who just civilian, right? Kid like 5 or 6 years old, sawing a American ambushing in somewhere, and they just, okay, we will not shoot children because they're just civilian. And then after that, it seemed that children telling Taliban, but that there is U.S. Army ambushing there. So all the U.S. military die, except the protagonist because he's the one who tells the story, right? So this is also the same kind of scenario, but it's easier because this Basu app is making civilian involved in any kind of military operation quite easy. So if we look at the patterns of involvement of civilian, we could group this kind of pattern into 3 levels. The first one is individual level. And the second one is civilian engagement as a group in cyber activity in armed conflict. And the last one was private tech company involvement in armed conflict. So what is the implication of these 3 levels? The key concern for the individual level is the scope of direct participation in hostility. So it means the direct participation of civilian as cyber technology is available for all. So it's easier for civilian to be engaged in and consider as a direct participation in hostility, and that civilian will lose protection. And then regarding the group level, it's leading to the challenge in assessing the organization level of the group to be qualified as a non-international armed conflict. And there are also other implication issues. And the last category, so participation of tech company, this raised the question of whether the shared IT infrastructure of private company become military objective for the purpose of an attack or not. And what is the consequence, what is the legal consequence, how IHL apply? So basically the general rule of civilian protection, I think as Dr. Panupat already mentioned that how can we define civilian in this contemporary armed conflict? So basically, civilian and civilian objects are protected during an armed conflict all the time. And how we define civilian and civilian object is a negative sense. So anything which is not military or armed forces or not civilian who participate in armed conflict, they are not military. So they basically civilian and are protected. That also include the negative definitions of civilian object, which is all the object which is not military objective. They are all protected during an armed conflict. But there is an exception. The exception is that civilian object, for example, could become a partly military objective if it's shared. Because in IHL itself, they didn't say directly how we can share civilian and military infrastructures. But in practice, in cyber world, you have to imagine that a server or a data center, in case of Microsoft, for example, Microsoft doing defensive measures, right? And these defensive measures, in IHL, they didn't regard whether it's defensive or offensive, but Microsoft data center, where they store all data, and that data also using as defensive measures against the attack from Russia. That could leading to the part of the infrastructure of Microsoft become military objective. But it has to be assessed on case-by-case basis. I not say that it's all cost because military objective has many issues, has many a way to assess this. But we do not have time to cover it all. But just in general exception. And the second exception is on civilian as individual or civilian population. So civilian will lose protection when they directly participating in hostility, and it's under Article 51, subparagraph 3 of Additional Protocol 1. So these leading to the challenge in the interpretation of military objective and scope of military of direct participation in hostility. This direct participation in hostility is not defined by IHL treaties itself, but there is ICRC interpretative guidance to define the notion of DPH. I just call it shortly as DPH. So usually in ICRC interpretative guidance, it defines direct participation in three kinds of threshold. The first one is thresholds of harm, the second is direct causation, and then the last one is belligerent nexus. So it is very challenging to make it clear whether all civilians conducting cyber or digital operations are not meeting all the thresholds of DPS. For example, the thresholds of harm require that an act must be likely to adversely affect the military operation. And looking at the case of Basu app, because you have to see, I think Andre has mentioned a very good point that in battlefield there's no dispute. There's no discussion whether we will shoot or not shoot because it's no time to decide. So that's why all the major power, they have military manual. And that military manual saying that, okay, in this case we do this, in that case we do not do this. That's why in case of Basu app, that is for me very scary. Russian troop could also see that, okay, that civilian holding a phone. And they don't have time to check whether that civilian having an app or not. They say, oh, because this app, I saw it on any Android app store and also Google Play, that it could be downloaded and it could use against us. So that we could shoot him probably in the guideline of the Russian could say that, okay, I'm sorry, I'm not accusing, but generally this is just only scenario, right? It's just an assumption that, okay, we shoot them because they holding this phone and we could see that this person must have an app. And that is the implication on this challenging of IHL. But what about Ukraine responsibility? Because you could see that Ukraine using this app and it make it available for any civilian. If we apply the passive precautionary principle under IHL, Ukraine should minimize the involvement of civilian because it cannot just take its own civilian to risking their life to be part of the target of attack. So that also what Ukraine have to think whether they have warned that civilian or not, that once you're using this app, there is a chance that you'll be a target of attack. And I have checked because I look at this description on the Google store. It didn't say that, okay, warning that if you have this app, you probably become a target of attack. So that is also one part that Ukraine as another part of the armed conflict, another party of the armed conflict, has an obligation to minimize the risking their life of their civilian. So I would like to come to a conclusion because we have discussed a lot of things. If you want to know more about this kind of issue, you could look at the ICRC website because there will be, I think in the future, probably in 1 or 2 months, there will be a release of positions of the ICRC that it's already out. Okay, I didn't check it. They didn't send it to me, sorry. Because I was part of the discussion at that time. So they will say what could be applied or how could IHL apply to this kind of new technology? What is the limitation? And come to the topic of our discussion today. How can we make this challenge as a national priority? So first of all, of course, I would like to advocate for the implementation of IHL, not only in form of treaty because Thailand has already transformed IHL obligation into domestic law. Some of the domestic law is in place. But what about the guideline for the military? I have never seen a military manual of Thailand, and probably I'm not quite sure whether it's available for general public or not. And even the decisions of the military court, I try to find it, it's very difficult to access. And with that implementation of guideline, of military manual, it makes clear how a Thai military can prepare in peacetime for the future of armed conflict. We are not advocating for armed conflict, but that's what we could prepare in terms of armed conflict, why we are respecting IHL to protect civilians. Second point that Thailand could do is that Thailand should have a national position on the applicability of IHL or international in general to cyberspace. Because in Asia, there's already 4 countries who already declare its national position. Why the national position is important? Because you have to see, I think just Raul has mentioned on this idea of Asian ambivalent and post-colonial. And you could see that Tallinn Manual, I would like to share my own experience with Tallinn Manual, which is the manual that was used for guideline as applicability of international law to cyberspace, and also that include part of the IHL. This Tallinn manual, they are basing on only 4 military manual, which is all 4 countries which are the member of the NATO. So I'm not criticizing NATO, but because that's it available. So basically, there's some country that has different kind of military doctrine, and some country that has another kind of military doctrine. So what Thailand would like to have in terms of military doctrine, we would like to protect civilian, or what kind of things that we can do and prepare for armed conflict. For example, all 4 countries has different view in the notion of attack apart from UK and US. So that also good things to see how this Asian country on how other country try to shape the interpretation of the rule of IHL. So that's why I would like, I'm so looking so much for Thailand to take it as a national priority. Thank you.
Thank you very much, Professor Papawadi. Indeed, I mean, we've been speaking on the different perspectives, tackling many different topics, but there's the core implementation of IHL that we have touched upon, the importance of integrating the law, dissemination, having the correct legislation. I think Thailand has some, for example, but not all. As Professor Vitit was saying, war crime legislation is not fully in place. It's rather old one referring to POWs, I think. So there's much more work to be done on that front. In relation to IAC, neutrality plays an important role and triggers certain obligations only in case of international conflict. In non-international conflict, neutrality is not relevant as such. The maritime neutrality has also its own concept and triggers also its own obligations. And it's important indeed to tackle that. Then there are other fields of law and other fields often defined by militaries and great powers as of strategic domains, which are indeed receiving a bit the impact of current geopolitical situations and tensions. And so all the processes aiming at clarifying the law in these fields are a bit refrained currently, given the current general pictures and relationships among states. And that's where states such as Thailand and others can play indeed an important role. And as Professor Papawadi was saying, there are many different ways of clarifying and asserting your own opinion in these fields. It could be developing a national defense policy where you already state that IHL clearly applies to cyber operations, and then organizing, for example, an expert roundtable tackling on how IHL applies to that. And then looking also at other fields of law that actually supports IHL, clarify IHL, or actually strengthen IHL. If we think about civilians increasingly caught in hostilities and actually triggered or pushed actually to take part in hostilities, whether there is direct participation in hostilities is another question. And needs to be seen on a case-by-case basis, as Professor Papawadi was saying, but then also think about also at the human rights obligations of a state, the protection of the right to life of civilians, the duty, of course, under IHL to spare civilians, which is actually an obligation of peacetime. So, and whether actually human rights law, in light of the current picture, would actually oblige states to educate the civilian population in the cyber field and sensitize on the consequences that in a conflict the use of technologies can trigger. Thank you so much to everyone. I enjoyed very much your presentations. I hope that was the case also with the audience. Now we would open the questions, the floor for questions. If anyone wants to be the first candidate. Yes. I don't know if we have micro. Ah, yes.
Okay. Thank you very much for all distinguished speakers. My name is Hannah. I'm Indonesian, and I'm a student from political science, Chula University. I have a question regarding both sides of political and legal perspectives. Well, to be honest, I've been waiting for the Israeli and Palestinian conflicts, by the way. But anyway, so if we depart from the first point, for having a conversations that, for example, international humanitarian law is of course part of international law, but also part of legal and political discussion at the same time. However, as part of international law, international humanitarian law also should be ratified nationally in order to be applied in national level, right? In a very specific scope, let's say Southeast Asian countries, including Thailand. However, if we talk about national practice and then ratifying international humanitarian law through its conventions, it's going to be a bit difficult if there is some kind of dissenting opinion, especially from the politicians. I would like to know your perspectives, like how to address the epistemological understanding to understand international humanitarian law to be able to ratify it in a national level and in order to be applied effectively in national stage. Another point is about the politicizing and securitizing humanitarian issue itself. For example, even though Indonesia has its own voice to say that we do really respect international humanitarian law and human rights in general, however, we ourselves also have our own issues. But in terms of the political system and political agenda in our own country, we do respect international humanitarian law as part of international law and try to integrate to our national priority. It means that Indonesia also tried to show that this is an entity, like state entity, that also uphold international law. However, it's just like different way to apply the international humanitarian law in our country. So again, my question, like how we try or influence the national politicians to shift their own epistemological thinking that international humanitarian law that is provided in international level can be ratified in national level in the same way and as effective as it's needed. Thank you very much.
Is the question specifically to any one of the speakers or?
All speakers.
All speakers, okay. So it's a multiple question. I don't know, shall we start with the first speaker?
Hello, Hannah. So good to see you. Thank you for coming also, Samindam. So it's good to see my students here as well. I think that I will address the second question rather than the first one because the first one is more tactical, and it's more specific to, I think, international lawyers rather than for political scientists like me. So for the second one, with regards to the politicizations and the securitizations of the IHL, I think this is one of the issues that, it's always at the core and the contestations between law and international politics, right? Because at the end of the day, even though we're talking about international law, this law has to be adopted domestically, no matter what. And the way that they adopted it is not simply just the adoptions of the entire international law. They can have a reservation also as well on the thing or the issues that they seem or deem not appropriate yet at that time of the adoptions. And for that reason, I think the other thing that's really matter is that how to shift the agenda. I think it's a kind of, there are multiple levels of possibilities that could be done. So number one, if I were to say that how domestic can actually shape the issue is that I would like to go back to what Andre was mentioning early on. I think three of us, and then Ajahn Pavadi later on also mentioned is that the implication of this happening in three levels: one regional level, second one national level, and the third one, the socialization itself. And these socializations of the norms and also the contents of the IHL within the domestic context, it doesn't have to come from the state, but it could be done from other actors within the states, and that means the non-state actors, including the CSO and civil society organizations. So the mainstreamings of some of the norms and also principles that enshrine international law, these could be something that could be done through the domestic actors, and then perhaps working together with, the legislatures and so on and so forth. I have to say that one thing that when we think about law doesn't change things overnight. Law is a gradual process of making things better over time. And because of that, what really matters is that the process of socialization, so people started to adopt the norms, it will eventually lead to the adoptions of all these different international elements that enshrine in the international law eventually. So for that reason, what I'm saying is that perhaps the target will not necessarily have to be at the legislature to begin with, but perhaps together with the domestic levels through the different actors and so on and so forth. And in fact, some of these implementation may already been done or interpreted through all those CSO or NGOs and so on and so forth on the ground, or even through academics who can serve as a bridge for all these different things. So eventually, I think it's become the kind of things that it could be done. And this thing also changed over time. I think in the context of Indonesia, also clear, right? Like even though certain things may not be upheld by the states, but in different local level, it could be done. Like for example, assistance that we see in some of the provisions towards the Rohingya populations in some of the areas was also provided, even though nationally it was not really the case, for example. So in that regards, I think that it's a contentions, and before compliance, it's always contestation. And I think that's something that matters, how we're going to tap into that contestations so that compliance eventually happen for the IHL eventually. That I will end it there.
Hannah, right? Yeah, Hannah, thank you so much for your question. I was fascinated by your term, the epistemological line. And thank you for that, Hannah. But I have one advantage here. I'm old enough to have seen the transformation within my country. Because when I was a student, we had already signed the Geneva Conventions, but people still saw it as pure politics. Even for me, I come from a left-wing campus, very close to the rebel groups. And it took a while, I would say maybe about 25 years ago. Some of you were not born yet, maybe at that time, but that we realized, the Geneva Conventions are treaties, and they are binding upon the state and eventually binding on the rebel groups. And so it is actually a transformation which happens over time. But let me identify for you some points which I felt where the epistemological transformation is easier to achieve. I call it the peer-to-peer conversations. There was a time the ICRC office in KL promoted this, and I was part of it. You see, soldiers talking to fellow soldiers. Judge Advocate General's office, the military lawyers talking to fellow military lawyers, doctors talking to fellow doctors, or for the Rome Statute, lawyers talking to other lawyers, diplomats talking to other diplomats. I think the realization that this set of rules are actually binding is the greatest strides were accomplished in those pockets of disciplinal conversations. Because then, I recall I did the briefing actually for the Philippine government, for the office of the president, and we were about to ratify the Rome Statute. And I thought I was briefing lawyers. It turns out it was a room full of people in military uniforms. And I realized, it was an uphill battle. The metaphor they used in our native language was, you sign this treaty and it's like getting a rock with which to hit your own head. And it's true, but eventually we ratified, and I guess for reasons not entirely normative. There were political groups which wanted it signed. But still for me, what pushed it toward ratification was, for one thing, the diplomats. They were in touch with the discourse outside the country. And they were telling people within the country, look outside, this is a normal thing. Submitting to a court, war crimes and crimes against humanity is not out of bounds, it's not a weird thing. For the soldiers, I felt their dialogues with fellow generals outside were telling them, the message was, this is what professional soldiers do. This is the honorable thing to do. You are a terrible soldier if you will hit civilians. You are a terrible soldier if you will hit a combatant hors combat, an injured soldier. You are not a professional and honorable man if you will hit a prisoner of war. So, it is within that discipline that it's easier to persuade. So I imagine if the generals are listening to a lawyer or to a law professor, they will say, okay, these guys are out to get us. But if they're listening to their fellow soldiers, then they realize, okay, within the discipline, it is already the right thing to do. But for me, you're right. The line that we should aim for is to cross from them seeing this as purely a political demand, a partisan demand, and for the armed groups to and for the ratifying states to realize that these are legal obligations. And just one last point, it's a finer point of international law. Well, whether you sign or not, some of them are customary law obligations. And maybe it's also a way to tell them. And so whenever in my country, the line of our former president and his followers is, international law, there's no enforcement mechanism for that. There's no global policeman. Let them issue a warrant of arrest. Let me see who will serve it on me. Well, I tell them, Putin was about to go to South Africa. He did not proceed. If the ultimate badass politician these days backed out of going to South Africa because of an ICC warrant of arrest, well, it does amount to something after all. I'll close on that.
Thank you, Hannah. Thank you for Judge Raul and Ajahn Panupat for your answer. I think you already covered a lot of things. So I would like to share from my own thought how address to the first questions of Hannah. So I thought that how can we advocate the state to be part of the treaty, to become party of the treaty? One, in IHL, one thing is that because in Thailand, we are a legalistic state. So we need domestic law as a guideline. For example, I think one of my fellow from another university, he's also here. He could also comment on my answer. I think there's one example, for example, there are a lot of discussion about the principle of non-refoulement. So not to forcing back for asylum seekers in the country or any kind of person who will face persecution to the place that will face persecution, non-refoulement, right? And that there are a lot of discussion amongst government agency that this is customary international law. So the lawyer think it's customary international law. So we will apply it anyway, but when it's not written, once it's not written, there's a debate whether we comply or not, because all the government agency, all the civil servant, they're afraid that they will do outside their duty. So they will face some discipline, or even they face some criminal responsibility. So for that, the success is that the non-refoulement was part of the Act on Enforced Disappearance. So there's no question from that. So I also apply the same kind of rationale to the IHL treaty. So if Thailand, as Judge Raul already mentioned, that IHL is not only in treaty but in form of customary international law. So if Thailand has no law, domestic law on that level, there will be a discussion whether Thailand comply with IHL obligation or not. And in case that, I will not say it could happen, but in case that there is a political tension in country, even though Thailand is not the party to the Rome Statute, did not ratify, just only sign, there could be some question of liability. I cannot think of this scenario, but that could be some way if we have political tension with another country. So that's what I say, that just to make it as a domestic law, so we have the guideline, we have the practice, make it in practice, so then we comply with it. So that's why make it clear for Thailand to defend itself for any kind of accusation, allegation, and also just to make it as an honor, as a military who comply to save life of civilian. Thank you.
Hannah, thank you. Those are very much political science questions and not lawyer questions. I can see it's really deep. I think I'll just limit my response to a small part of it, and that is mentioning dissenting opinions. I think it was already indicated, customary international law is there, but we must recognize that usus and opinio juris, the elements that make up customary international law, especially in the field of the law regulating armed conflict at sea, a lot of it is customary international law. And we see that the debate continues. There are dissenting opinions. So I thought I would just make this remark. I don't think dissenting opinions are ever going to go away. The same can be said for politics when issues of IHL is discussed. The debate is a reality, but that's where things like the rule of law is important, and things like the ICC contributing to jurisprudence that silence some of the debates on key IHL issues. So there is a point where countries that have strong laws and strong rule of law silence the debate because they've implemented those things, and there's a final answer. And I think I should refer maybe to my own country, South Africa. The ICC debate started long before the present example given. There was previously another president who was sought by the ICC who came to South Africa. And that process was finally concluded through the courts saying this is the legal position. The government has a duty. So I think, despite courts finally saying that, there will always be some continuing debate. And I think I want to raise this. We must make sure that we raise our voices too. If there's dissenting opinions, dissenting views, sometimes those views have a political agenda. Now, the ICRC is neutral, impartial, independent, and we don't get involved in the politics. But when it concerns IHL, there's definitely the situation where IHL could be weaponized, could be argued, could be doubted to say, well, to achieve a particular aim, we don't think this is the extent of the law. Challenging the law. And there I should cite, I think, Margherita, if I have it right, the respect for the law on the battlefield, IHL in action. The ICRC has this ongoing study where we collect examples of compliance. That's just one example I want to mention. Newspapers don't write stories about things that went well. They write stories about things that went wrong. And debates usually center about things that went wrong. But for everything that goes wrong, there's usually an abundance of examples where things went right, where we don't actually debate the law. And the danger of allowing debates without voicing all the opinions, even the ones that support the law, is that one might be led to a position to think, oh, but the law is really unclear in general, and it's really not sufficient. And from an ICRC perspective, I thought I'd just raise that, and I think you raised an important issue there, dealing with dissenting opinions. It's very important that we don't throw the baby out with the bathwater. And this is particularly true for maritime issues. There are so many issues that are very clearly defined in law that everybody agrees about. Yet you frequently find people saying, oh yeah, but it's very old law and it's very unclear. And I just want to counter that. Be the voice to say, well, that's not true. There's strong law, there's good law. In most instances, yes, there's points where we debate. But it's so important to also raise the voices as lawyers in support of the law that we believe is there and that is strong, to counter, I think, those voices. The last thing I should say is, it is possible, of course, if you take how Kashmir International is formed, to cast doubt on the position of a particular legal principle by raising dissenting opinions. And for that reason, it is very important for states, I think, as was already said today, states to have positions and to have views. Because it is interesting sometimes if you let everybody in the room speak, actually it comes to a different conclusion than letting the ones who speak the most and the loudest to just speak. So by that, I don't want to make a political statement. I want to really reflect on a human reality. We must, as lawyers, add our voices to those debates, support the law where we can, and not allow debates to erode law that has cost a lot in blood to achieve what it has achieved today.
Okay, thank you. I would add to that sober analysis is important. Today we need sober analysis and arguments. I think with misinformation and disinformation, everybody expressing their views, this is important. But there's also this trend that we need to take into account. Other questions? Yes.
Can I throw like two questions at the same time, please? Yes. So I'm Benjamin, and I also practice international law. So this is directed to the statement of Mr. Smit, and at the same time, Ajahn Bonapan. So basically, Mr. Smit was very talking about planning and practice. But at the same time, you brought us to the ground, Ajahn, by saying that we are operating actually in a real politic. There are geopolitical realities. And at the same time, there's always the problem of sovereignty. So, Mr. Smit, it's easy to plan and at the same time impose a plan to those weaker than you. But it's almost impossible to convince the powerful to be able to follow a plan and to practice it. But at the same time, you said, without a plan, we will achieve nothing. So in this particular state of affairs, how can we balance realpolitik, but at the same time advocates of international humanitarian law, create and convince the powerful to be able to respect it, knowing that it will be civilian lives at the end that will be at the losing end always. It's not the powerful who are at the losing end. So that's the first question. The second one is, this is for Dr. Papawadi. During the introduction of Dr. VT, he used the very creative, he said, IHL is a breach of peace. But at the same time, he ended by saying international humanitarian law and international non-humanitarian law, recognizing the importance of drones, cyberspace, as a mechanism for destruction. And then you mentioned the app, which actually directed the drones to be able to inflict significant damage to Russian or Ukrainian forces. So in a way, the planning and the practice of destruction of war is actually more widespread. And we don't have an idea of who are the participants in this war. Of course, because of the nature of the apps in participation. So do you think, Dr. Papawadi, do we need to reinterpret IHL as written right now? Or do we have a different version of IHL, recognizing that cyberspace attacks and everything is a more potent weapon of war? Especially we're approaching the use of drones, non-autonomous weapons, and at the same time, the potential conflict for nuclear war. So thank you very much.
One or two more questions, and then we try to respond to everything. So, any other questions? Yes. Sorry. Apologize. Yeah. It's...
Hi, my name is Phil Sankrai, a lecturer at Faculty of Law, Thammasat University. So I just want to sort of continue this dialogue on, encouraging states to take positions or more broadly participate in lawmaking in general. Perhaps sharing my sort of limited experience with the Ministry of Foreign Affairs as well. So I was invited to the meeting on, what to be the position of Thailand in the draft articles on crimes against humanity prepared by the ILOC. So I was preparing, what should be the position of Thailand, so on and so forth. And the framework that I was trying to think with at that time, and perhaps still now as well, is what would be the national interest of Thailand. So that's the key word for government officials, and back then there was military participating as well. So that's a framework that I was thinking with. So I looked at the countries and the policies of many countries, especially in Europe, that were active in this area, including war crime as well. And I was presenting that. And it turned out that Thailand wasn't taking any position at the UN, at least back then, as of now as well. And to sort of add to the to this, so you are aware that there's a very new convention on international cooperation on prosecution and investigation on crimes against humanity, genocide, and war crimes. From what I know, Thailand was invited, but they again refused to participate for whatever reason. Perhaps it was the question of national interest as well. So. My question to the panelists, to the speakers, is that the right language and framing that we should think about, or should we change entire frame to encourage officials to take part more broadly in international lawmaking in this area, both international criminal law and perhaps IHL as well. And just to end on this. Professor Pangalangan spoke of this, Asian ambivalence, and his analysis that perhaps states, governments in Asia are reluctant to be bound beforehand by, adjudicatory bodies. Now that I agree when it comes to ICC and perhaps, human rights adjudicatory bodies, but it's also curious how that is so field-specific in a sense that if we look at investment law, if we look at trade law, WTO law, these countries are so keen to be bound by investment arbitration, compulsory dispute settlement by trade law. So that's something to think about. I think it's not court as such. Perhaps it's perhaps more field-specific, more. Perhaps it's national interest. Perhaps these states see national interest in having more and more and more provisions on investment arbitrations. Thank you.
Thank you very much, Ms. Yostero from Civil Society Nonviolence International Southeast Asia. I would like to jump onto piggyback on those two other questions, the victim centrality of IHL and also on the details on the treaty's applicability when it comes to national law. For example, especially when we are comparing the theory in practice and we're talking about the protection of civilians and the victim centrality of IHL and their protection, how do we then encourage legislation? Because politics with legislators is very different from international multilateral platforms. How do we then encourage the legislation, and maybe the panelists have experienced this in the different areas, regions that you have encountered? How do we protect the rights of civilians and clearly define the difference between civilians and combatants in national law implementation, especially when we take into account the armed conflict realities on the ground? For example, if there is an aggressor, an invasion, on the ground, you have civilians, you have children. I will focus on children, for example. You have suddenly children who become orphans and are left to defend themselves. If these children, for example, a Palestinian child, will pick up a stone and in front of armed soldiers, does he then become, under law, does he then become a combatant? In Ukraine, if a Ukrainian child is left, alone in a place where he sees soldiers, Russian soldiers, and he has a phone to report where he is, does he then become also a target? Can we not put that has that been not put in any national law? How to protect the distinction of civilians, especially when we're looking at realities on the ground, freaks. So it's very much the same case in Myanmar, where there are children left in the care of armed groups because they are running away and their parents have already are dead. So this is like, can we then say that once they enter a camp, a state, rebel camp, are they then defined as a child soldier under international law? So that's my question. Thank you.
Okay, we'll take maybe this round of questions. I think the first group of questions were for Professor Papawadi and...
Maybe Andre first.
Okay, sorry. Then Andre and then Professor Papawadi and Chula. Yeah?
Benjamin, thank you. I must just clarify. I think I understand you to ask, in summary, how do we convince the powerful? That was the phrase that you used. But I did want to clarify. If you say that, are you referring to one state convincing another state of the utility of IHL, or you're referring to the population of the country speaking to the leaders of the country?
I think in my mind, it's most about the community of states, but at the same time, those who we must actually convince, the aggressor side, the powerful side, are those who don't actually, as Judge Pangalangan said, will not be willing to hold a rock to hit it to their head. So how will we convince them and make a plan and for them to participate in this plan project, which we call IHL? Because without their participation, it will be just a plan in the sky. That's a framework.
Okay, thank you. Thank you for clarifying. I think that's an excellent question. Let me start by saying IHL doesn't itself provide the answer in an IHL mechanism on that. Going back, I think, to the core of what IHL is, and in particular the 4 Geneva Conventions being universally ratified and having the status of customary international law. I think we've passed the point of convincing in general. We are at the point of convincing sometimes in detail. What do we mean with particular provisions? And in that regard, I think that is what's so nice about something like this, because it's not only law and it's not only lawyers. We need political scientists, we need politicians, we need skilled civil society, we need humanitarians, we need victims to come forward and convince. Because in the end, I believe firmly, it is in the state interest to adhere to IHL. It is. If you are serious about your population, this is protecting your population. You can talk about it all you want. In the end, it is in the interest of every single person that there exists IHL and that their countries implement it. That is something that you won't necessarily find in IHL. IHL doesn't have that mechanism to convince states. The law has that mechanism. If it's the law, it's enforceable. The question is, to what extent is it implemented domestically? And then this big question of how do we enforce international law against the powerful, against the P5, those that have the veto, and there are much greater lawyers than I that still do not have an answer. So I won't even propose to give an answer. But I agree, it is a concern, it is a big question. There's many things ongoing, even including, I think, revisiting the international order, even at the UN, because it's not only an obstacle for IHL purposes, that's an obstacle for much greater other humanitarian purposes too. So yes, bring it, I think, just back to the plan. How do we, I almost want to venture to still say, that doesn't mean that planning and practicing it is thrown out of the window. I think we do indeed need to have a plan, because we know we encounter this. We know we encounter powerful states that may be difficult to move towards a position where states agree this is the law. What do we do with that? And there's so many good examples that I think political scientists are better to address than lawyers. But examples where small states have achieved things through working together, regionally especially, forming blocks, raising issues over many years until they become issues that many states take up, where it becomes so powerful. And there's good examples, but because I want to not contextualize, I think I shouldn't name any country names, but small states have been successful in moving big states. It's unfortunately not a legal answer. It's very much a political science answer. Yeah.
I think I will address all the question, because some question that could be combined together. For Benjamin's question regarding the reinterpretation of IHL in terms of autonomous weapon or cyber operation. So basically, as Andre has mentioned earlier, that IHL is a law, and the law was formed at the time that there's no this type of technology. But what IHL, the ultimate goal of IHL itself is to protect civilians. So basically, when we have to reinterpret IHL, for example, in the use of autonomous weapons, in terms of IT technical, they may say that, oh, AI is so good in targeting and distinguish between civilian and military personnel or military objective. But that should be because we have the principle of humanity. For example, as one of the participants mentioned about whether if in case that the children holding the phone and trying to take pictures of the movement of Russian troops, whether that military should spare the life of the children or should shoot the children or not. So basically, this principle of humanity is there, but usually shooting children is banned, right? But basically, shooting children or to justify by military necessity, this kind of thing is based on the fact on the ground, and it was implemented in the military manual of each country. So that's why, how can it make possible in terms of practice? Because in military, there's no time to dispute. So that's why in military manual, it will say what could be do in this kind of scenario, and they have to practice about this. So that's why they could doing it according to the military manual in different kind of scenario. But some countries do not share the military manual at all. I would say I studied the German military manual itself. They even say what kind of attack in terms of cyber, what it is, and what could be, what could be part of defensive or what could be part of offensive idea. So that is clear, and that is define the action of military at the battlefield. So they could comply with IHL. But the problem is, as I said earlier, that there is different kind of military doctrine. If you talk about law of self-defense, which is another law apart from IHL, under the US dominance, they have different view in terms of the occurrence of armed attack. So that's why the national position first, and national position to external idea, external relation. And then the second level is implemented in military manual. So that's why they prepare and they practice. And address to the question of Phil, my dear fellow from another university. In fact, I was graduate from Thammasat, for my bachelor degree. I think Phil has mentioned very good point about how Thailand very active in terms of investment treaty, trade negotiation, and FTA. We are very active. So it seems that Thailand is very economically oriented. But what about the idea of IHL? I think the way for Thailand to change the perspective, as Phil mentioned about national interest. So that also could be raised through the accountability of military. I think with the new election, you also seeing the atmosphere that, okay, there could be a reform in Ministry of Defense to reduce the number of the generals, so the financial support will not be that high, so we focus on the other important things. So this is also part of the reform that Thailand, if we would like to have the new military corpus, so we should think about this accessing and to IHL treaty and also implemented it at the national level. So that is what I would like to cover. Thank you.
Thank you. Anyone of the speakers wants to add maybe a few points?
Add one last thing on the question of national interests. So perhaps a person is from international relations to start that conversations with international interests, which I think I'm happy if I hear that, at least from MFA, when they start talking about that questions of national interests. But again, I just want to make clear also that even though I'm talking about geopolitics, real politics, and also national interests, doesn't mean that we all completely disregard international law in that sense, and particularly I think when it comes to the question of IHL, because I think one thing that is really important to recognize also is that when it comes to national interest, of course, it leads us to understand one dynamics of international law at large, and that says the states are the one making international laws before the international law becomes something that get enforced toward the states. I think these dynamics right here is quite important, either in terms of the international customary law or even in terms of the enforceable laws for those ratified the conventions and so on and so forth. But I think what is really important for me that I really have to emphasize here is that when it comes to the international order, and then particularly with Judge Raul was mentioning about the Asian ambivalence, I think one thing that we need to maybe classify is that there are two Romes when it comes to international law based on political considerations. One is the civil and political Rome, and then the other one is economic and also social Rome. Based on your discussions, it seems as if the economic and social Romes, it's the one that the developments kind of go quicker, right? When comparing to the civils and political Rome, that things kind of proceeds slower. But in fact, I would say that the role of politics that's going to come to play in shaping of this law is that actually, even though sometimes international treaties are not ratified, that doesn't mean the states does not practice those international customary law. In fact, like for example, when we talk about refugees in Thailand, right? I mean, officially, Thailand does never recognize the 1951 conventions and the 1967 protocol. But then refugees are there in Thailand. And just recently, Thailand also been adopted, I mean, and then also created the regulations which, you know, on the screening mechanisms to screen the protected persons as well. And even have the definitions of persecution, what it means to get persecuted. And the definitions also including war of aggression and so on and so forth. And severe human rights violations, which even beyond the scope of definition within the convention itself. So in that sense, you know, I think that, you know, like perhaps the political will for the development of the civil and political realms of international law might be there, but it might require the political entrepreneur or the policy entrepreneur to be the one that really help shape, you know, like implement the adoption at the same time the mobilization of resources. So in that sense, we go back to Hannah's questions early on also, is that, you know, like perhaps when we talk about domestic politics, in the interests of the nation, because of the nations are the ones that are creating it.
Yes, and if I may quickly add to that, because I think we're seeing interesting developments, I don't want to go to specific examples, but we always say at the ICRC that IHL is one war behind. If you think about it, the 1940, the Geneva Conventions were developed after the Second World War. Then we had the protocols after the so-called decolonization wars. Now new technologies. Let's see. Hopefully, we agree on a set of rules before massive humanitarian consequences get observed. Although we are already seeing cyber attacks actually in current armed conflict. But cyber has also some advantages because you can neutralize an object instead of destroying it. So, but the interest and the economic interest, I'm not, again, a political scientist or I'm really a lawyer, but states, when they realize that it's in the own interest of their own population to not lower those standards they have agreed on, or that those standards are actually missing, they realize that actually that branch of law is important. It takes much more time, as you said, because you need to make it tangible, unfortunately. And that's also our role with Andre, to raise, you know, that maybe it doesn't concern you directly today, but it's concerning others and several, and therefore this is a problem, and therefore it may concern you in the future. But somehow it's true that in the persuasion we need to make it tangible, actually even before facts happened. But when people are concerned, and you don't need to have an armed conflict in your country actually to see that states react. Just one more point, sorry, I just wanted to clarify maybe, because you referred, we spoke about cyber and then the risk of civilians taking part in the cities. I just want to clarify that, because this is important, that IHL applies in armed conflict, and therefore the direct participation in the cities is relevant to the extent that there's a nexus to that armed conflict. ICRC view, because I heard it also in relation to non-refoulement, we can make it clear here, is that, for example, IHL is geographically bound. So, for example, the conflict, Myanmar has several non-international conflicts. Doesn't mean that there's any spillover of, you know, that conflict in Thailand. IHL applies in Thailand. Everything would need to be of the case. Yeah, sure.
I just want to respond to your point. You actually have raised an excellent counter-argument. So you mentioned that Asian states apparently are more willing to submit to arbitration. I think the Paris group, the International Chamber of Commerce, has its own office in Singapore. So you're correct. And indeed, they piggyback also on existing frameworks, ICSID, through the World Bank also, and the World Bank Sanctions Board as well. Well, you're right. Maybe for commercial matters, they are open to it, but not for the more amorphous human rights matters which are seen as therefore more political. The other is, back to my theory about peer-to-peer conversations. Well, the business elites among themselves might be more convinced that it's easier, maybe cheaper, more convenient to resolve matters this way than through, government-level sanctions. But I think the most intriguing point, and I have no answer, is really why they are more sensitive for human rights matters rather than for commercial matters. But I will put IHL even outside that spectrum, because IHL is well defined. It is the principle of distinction, the principle of proportionality. In fact, for me, the most important point about IHL is that it is to the mutual interest of the armed groups to behave themselves. And of course, there's some disparity when it comes to non-international armed conflicts, but still, the incentive system is there, in contrast to human rights, which is a unilateral obligation of states to individuals. But I'll just close on that. Thank you.
Thank you. Thank you very much for this, to be part of this conversation. I'm Fred Lubang. I'm involved in many humanitarian disarmament campaigns in various levels. And being involved in a number of verification missions, looking at violations by armed groups and particularly by states, I think, and just to answer, I think, on the challenge of having this kind of framework or some kind of a mindset raised earlier, I think the best way really is for both sides of the parties, warring parties, to step up on IHL adherence. The mindset should be the side which has better IHL adherence or human rights adherence should win people's hearts and support, and not just to win militarily, but morally. And this has to be the standard. And if we look at the region, there's just few countries who are now currently involved in wars, internal or some kind of a threat. But when you look at it, even the armed groups, for example, in the Philippines, and we've been following this case, the New People's Army admitted that they violated their use of anti-personnel mines in the Masbate case. And we would like to at least see some states at some point admitting and trying their own. Just like the Australians defense forces who tried their own for the violations of the forces in Afghanistan. And so it's more of that, truly to discipline yourself, punish yourself, to be able to have that kind of a sense that it really is implemented. And the other part, which is really more of, I think, a question for some lawyers is, and Judge Raul mentioned this, of some kind of a fair labeling. It's also difficult at the national level because most of our lawyers in the Philippines, for example, we have a national IHL law already, but they're not filing cases based on that because they said it's easier to file murder case or other crimes. And so the challenge really is, yes, I do agree with the perspective that we have to strengthen the local regimes, but on how is the part and the capacities of all actors, not just lawyers really, but those who would like to see this as some kind of strengthening national IHL implementation. And the second point is more on when it's so, just look at Ukraine and Palestinian, it's so intense, the intensity of extremely biased propaganda, that truth always gets the first victim, as they said. So what institutions, Doctor, I feel that your name mentioned about institutions, what are you thinking about institutions that are seen to be independent, that would really seek the truth? What kind of formation is this? Is this the Commission on Human Rights institutions, or are you looking at the different institutions? Because that's where I think truth would come out, and transitional justice, we will not repeat it again once we see the truth. And finally,
on a lighter question, as a fellow moot court judge in the Philippines, a question to some who are involved. How do you address when lawyers or potential lawyers contorts the IHL? We've seen arguments that they really contort IHL, bend it to benefit arguments. And this is seen even in today's Israel-Palestinian conflict. And there's some sense of how do we change that? And so it's more of the training on future legal minds and even people who would like to go into IHL field. So again, thank you for this opportunity.
I suppose one question was for Judge Pangalangan, maybe. And I don't know if you want to answer the three of them. And then we can see who wants to jump in, unless there were specific speakers to which you were directing the question. So, Judge Pangalangan is fine? Yeah, okay. Okay.
I'll take on two of the points. The first is let me just start with the last for the moot court. Well, I think what you're looking into is the mindset of the lawyers of manipulating arguments to arrive at a certain conclusions. Well, I am of two minds there. I mean, that's the nature of the game. If the legal argument, if one side will use arguments for its own desired conclusions, then the other side will do the same thing. That's the nature of the game. But the other is now looking at it not from the standpoint of the advocate, but from the standpoint of the judge. I share your concern. I call it the consequentialist view of legal arguments, that sometimes partisan groups will take a different position depending on which way the wind blows, depending on which argument is good for the day. I'm trying to look for I can't think of a specific IHL example, but in my other field, which is constitutional law, some doctrines will be invoked in a different way depending on who is the winning party. So I share your concern, but it's just that it's almost part of when you enter a conversation on legal grounds, it is almost like part of the professional hazard that we have to deal with. Now, I'm trying to recall your first question that I wanted to reply to. Yes. Thank you so much for reminding me. Well, there already are IHL cases filed in the Philippines. The first was the Hunaid case of forced marriage done by one of the Islamic rebel groups. And in fact, I posed the same question. I have posed the same question that you asked. Why charge him under the IHL law for sexual offenses under IHL, when in fact part of the evidence of the court was 16 cases of rape? It would have been easier to do that. They would not have had to bother themselves with the increased elements of crimes to be established if you treat it as an IHL law offense, when in fact it would have been easier to prosecute under the revised penal code on rape, and you would have 16 counts. Thinking as a judge, I can impose as many penalties as I want. I actually got the answer, because apparently one of my students in that class, and it's an LLM class, was a colleague of the prosecutor in that case. And her answer was, my colleague wanted to test the law. There was a new law, she wanted to use it. Even if it was more difficult, she did it. And I like the spirit as a professor. I like that someone was using the IHL law, but I don't blame prosecutors for taking the easier path. But just one last point. I was lecturing before judges for the Philippine Judicial Academy. I show them the headlines in the papers that the rebels, again also in Mindanao, executed a farmer, conducted a trial and executed the farmer. That was a violation of IHL. It's an extrajudicial trial. I asked them why not prosecute criminally for that case. It can either be an IHL violation or a pure or straightforward murder case. I mean, they murdered the farmer. And one of the judges said, sir, I come from that area. If I want to serve a warrant of arrest on that rebel group, no sheriff will be brave enough to enter that area, which shows really that, well, apart from that general difficulty, it cannot be treated as a traditional murder case. It has to be treated at the level of IHL because because of the circumstances under which the killing was committed. Thank you, and thank you also for reminding me.
My duties. Maybe I think the other question was for Dr. Yes.
The institutions questions, right? Like
Exactly.
which have institutions I was thinking in my. I'm not sure, to be honest. To be honest, I'm not sure. The reason why I'm saying this because I think that the specific context that matters a lot. But then for the IHL to actually be grounded, I think another matter that really important also is to actually think about certain groups that are not even aware of IHL to begin with. In this case, also means some of the groups that are operated in isolations and so on and so forth. So it's lawless in some sense. And in those cases, there were instances of that, I think, in the ongoing armed conflict as well. And because of that, even though there was a clear violations, but that means that eventually the elevation of IHL as a national agenda, either through the national mechanisms or other mechanisms to ground it in those places where they're not aware, would be something that's needed also. Yeah.
Okay. Thank you very much. Just maybe one note on the murder versus war crime. It's really an obligation to prosecute if it's a war crime, up on the war crime flag, and training and recalling it to judges and lawyers is very important. And this is also relevant for terrorism now, which is the new trend. But what is terrorism? We don't know. Well, we know what is a war crime. And it's an obligation to prosecute. Thank you very much to all. And thank you very much to the speakers and to you for the excellent questions and for triggering interesting debates. I hope this will be only one in a series. I hope to have more and even more of you here. I wish you all a very good rest of the day, and thanks again to all the speakers for your passions and presentations. Thanks.